Welcome to You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar. I have my own practice in Chicago whereby I concentrate in family law, medical malpractice, and personal injury. Illinois has joined 39 other states in adopting the, quote, income share model for calculating child support. These laws will be coming into effect around July of 2017. They're based upon data that measures the child rearing costs, which we never had before, especially under the present statute that we have, which are the guidelines. These costs are allocated between the parent based on each parent's respective net income. We've used a guideline formula that we're using now since 1984, based upon a percentage of the obligor's net income. This increased for each child of the parties. Example, 20% for one child, 28% for two, 32% for three, etc. This is now considered outdated. It does not reflect the rearing costs or allocated costs between the parents. I have with me today a guest, Mr. Burton A, who has been practicing about 50 years in Chicago and in family law only. And he also is a, quote, super lawyer from the Chicago Law Bulletin. Bert, thank you for being here today.
Barry, thank you very much for the opportunity to be with you. And just for the viewing audience, so they know, you're looking at 100 years worth of experience sitting at this table. Unfortunately, Barry said I have 50. I intended to say he had 70 and I had 30. Go ahead, Barry.
Any way you fly it, it will work. Only 7 states use this percentage guideline method. It causes discord between the parties and distrust of the child support system. Income shares that we're going to be talking about today reflect families' actual child rearing expenses, how they are shared by the parent prior to a divorce or separation, and it reduces the negativity between them. It benefits the child and it improves support collection and coordination of interstate child support payments. The income share model can produce child support amongst higher, lower, or compatible to those of percentage guidelines depending on the respective financial circumstances of each party. There's an assumption that child support determination is using the income share guideline is a correct guide. Income sharing states receive their child rearing costs from data from the Bureau of Labor Statistics. It's based on child rearing costs that maintain a standard of living that the child would have enjoyed if the parents did not divorce or did not get separated. In Illinois, it will be based upon the data from the Bureau of Labor Statistics adjusted for Illinois and be updated periodically. Like other income sharing states, Illinois uses an economic research institute to prepare the schedule. In anticipation of this new legislation is a simple sample expenditure table in 2012 prepared by HFS. We hope to have one of these guidelines or worksheets or calculators displayed on the film right now that you'll be watching. And so if it is, you will see what we're talking about, and I will also show you one here today. In fact, I can show you one right now and give you an idea of, and this is from a Connecticut statute. I don't know if you can see that this far away, but it indicates per week. That's what Connecticut uses, the guideline per week. And it has a whole schedule for how much you make per week, and it tells you what you pay in child support. Business income under this new statute is defined in the new law, and it reflects depreciation or excessive business deductions and personal expenses through the business. So we all know that if you have a law practice and you go out and buy an expensive camera and say that you're taking pictures of automobiles, then it may not be really all for the automobiles. It may be used at home socially probably 90% of the time, and this is going to be cut out under the new act. New computation of net will allow for deductions for federal and state, including Social Security and Medicare. Standardized tax amounts may be appealing for simplicity, but unlikely to reflect the actual net from the party who has numerous itemized deductions. To determine the percentage of income shares between the parties when spousal support is paid by one parent to the other, maintenance must be subtracted from the payor's parent's income and must be included in the recipient's parent's income. I can go on and give you all these common clauses that are going to be in the new statute. Illinois has filed a basically, we'll say, the statute of Connecticut. My personal comment is it's going to be a big headache. It's going to see a big turn in the road and a surprise boulder in the center of the road. And I'm going to get into that in my discussions with Mr. Gross here today. And we're going to talk about how the statute will affect people who have to go back into court because let's say one of them is not getting visitation and they had their child support entered under the old law, and now we're going to be seeing a lot of people coming into court talking about, I want child support under the new law. So now I leave it up to you, Mr. Gross. Tell me what you think about this new statute that's coming into effect in July of 2017.
Well, to begin with, the old statute, which gave us the percentage guidelines, were really a boon to lawyers and a boon to their clients because most areas in divorce are kind of gray. There's no black, there's no white. The courts have wide discretion in what to do. Once the guidelines were put into effect, basically 99% of all cases ended up being guideline orders, as you know. So when a client came in, you were pretty much able to say, this is how much you're going to get in child support. Now, there were other issues that would come up like child care expenses, educational expenses, not college, but educational expenses, extracurricular activities, and how were these going to be split. There were arguments under the old act about whether or not the court had the ability to apportion those kinds of expenses. Most judges did, some didn't do certain things. Under the new act, again, we're going to have some stability in terms of predicting what a support order is going to be. The new act also takes into account these other matters and specifically authorizes the court to deal with them. Doesn't tell the court necessarily how they're to be split, just says deal with them. On the issue of the child support, what we're attempting to do under the income shares model, and I'm not a big fan of it to begin with and haven't been for the last 30 years, but the idea behind it is to look at the incomes of both parents and say, okay, we have one child, the expenses of raising that child are X number of dollars. Dad's income is 2/3 of the total, he'll pay 2/3 of that amount. Mom's income is 1/3, she'll pay 1/3 of that amount. So it's fairly simple. And for practitioners, we have software that we use, which when you put in the information as to what their incomes are, it will calculate how much tax is going to be paid, both federal, state, and local, and will take into account other things that are deductible from income to arrive at net, and then you apply the percentages to them.
Well, I say, Mr. Gross, Bert, as I'll call you, it's not that simple. And I think that not every lawyer has the software that you're talking about. But I know this, when a woman comes into my office and she says to me she's going to retain me for a divorce, and she gives me the name of her husband's lawyer, I call him right away and I say, look, we have 2 children here, that's 28%. Send me a copy of his last 5 pay stubs and a check for child support. Let's start it right away. We don't have to go to court. Now, sure, there's exceptions to everything. But under this new act, which is going to be income sharing, and I don't even like the nomenclature that they're using, but let's assume that that's what it's going to be. You're talking about an additional 7 to maybe 10 or 12 court hearings. You're talking about those lawyers stuffing their pockets with a lot of money now because there's going to be a lot more hours of work. I tend to think that it's going to be a little more complicated. You're going to have expenses now brought into the playing field, which you didn't have before. And expenses can vary. And then there's going to be arguments. He owns a business and he writes this off and he doesn't write that off, or he does this and he doesn't do that. There's going to be a lot more hours of work. So you're making it very simple. And sure, you think the average layperson is going to go out and buy software? I don't think so. And I don't think that every judge is going to be computer literate to be able to use software. I find that now that there's many judges that use software and there's many that don't. So I think you're going to have a lot of court hearings, and you're going to take these court hearings are going to take, instead of taking 10 minutes, it's going to be at least an hour, and it's going to really chop up the court's time to a great extent. If that's what and then the guidelines that we have today, that's what it eliminated, was a lot of court time. And now you're taking it all back. So let's go on and,
Oh, can I just disagree
Sure.
with you for a minute?
please.
All right. Whether you're talking income shares or you're just talking a percentage guideline, let's forget for the moment that you can calculate what the number is with the software, which you say maybe some people don't have. The simple fact of the matter is it costs $50 a month to have it. And if you're in the law business and you're doing divorce work, you have to have it. There is just no two ways about it. It's a cost of doing business. But going to the percentage guideline, yes. Can you calculate 28% of the net for 2 kids? Absolutely. Then your client says to you, oh, but Mr. Gordon, Johnny is taking soccer practice and soccer lessons, and he has uniforms to buy. And Jill is taking piano lessons. Well, what about those? You still have to deal with them. You're dealing with them under the percentage guideline, where a judge may say, well, maybe I should consider them and maybe I shouldn't, and that creates an argument. Under the income shares, regardless of whether I personally like it or not, the court specifically has the authority to deal with those things. So you're going to end up in court probably no matter what. That's my practice, at least.
Okay, that's understandable, and I see where you're going there. You know, Illinois has taken a good portion of this new act that's going to come out from the state of Connecticut, who's had it for a while. Their statute is very comprehensive. It's not only does it define each and every word, it defines gross income, net disposable income, schedule of child support obligations, child support, shared physical custody situations, child support with another child residing with the parent. I can go on and on and on.
Yes, you can.
And it's a very detailed, comprehensive statute. They came up with a calculator that I hope will be shown on the schedule here today. I'm showing a picture just to the audience right now, and it's based upon, as I indicated earlier, it's based upon a weekly net, not a monthly net, and it basically calculates based upon child rearing costs and everything else, so it's easy to look at. So I got to give Connecticut a plus for that, and if Illinois adopts something similar in nature, I'll have to give it a plus. So let's go on, and you prepared, I understand, a situation that may be good for the viewing audience. Let's talk about it.
All right, just as an example,
Yes.
we're talking about. Yeah, I put together something that would be done in Illinois, where we have 2 parents, Sally and John. I've given them each income. John's, of course, is somewhat higher, and the software I'm talking about, and I don't know if this can be picked up, probably not. Basically, the software calculates what the taxes are going to be for each party, what other deductible expenses they have, and then it arrives at net, where Sally's net is $18.59 per month and John's is $45.52. Total is $64.11. The software then determines, based upon the amount of income and the number of children, what the basic support obligation is, and then allocates it between the parties based on their respective percentages of the total income. So that's why I say it's simple to do. Then there is one thing that came up in the income shares approach, which is a factor we had to deal with for many years now. The idea of shared parenting. Shared sometimes meant equal, sometimes it meant something less than equal, but you would have the payor, and we'll say for the sake of discussion, it's usually dad. Dad is saying, well, I have more time with the kids than most of the fathers I know. Shouldn't I be entitled to a reduction in child support? And this was not something that was universally dealt with by judges. Some judges said, sure, we should give you a break. We should go below the guideline. Some judges said, you know what, you're getting more time with your kids, just be quiet and appreciate it. But it doesn't give you a right to pay less in support because mom's expenses are still pretty much the same. Under the income shares, there is a thing called shared parenting, which is defined as having, for the person who doesn't have what we used to call custody, at least 146 nights a year. Once you have 146 nights a year, then we call this shared parenting, and then the software redoes the numbers based on this percentage of time that you have with the kids. So a battleground obviously is going to be somebody wanting to get to 146, because that's their magic number.
I
What
understand.
it'll do, of course, is reduce the child support obligation.
Yeah, you know, it's going to be very difficult for the legal profession now to start explaining to the litigants exactly how we are defining what shared income is and what the amount is, whether we use a calculator or a worksheet, however we do it. It was easier before by saying, look, there's 2 children, it's
Absolutely
28%.
true. Absolutely true.
It's marvelous. It worked. It was beautiful, and now they're changing it.
But on the other
yeah.
hand, Barry, if I could interrupt you for a second.
Sure.
We've been using the word dissolution to describe
Yes.
what we used to call a divorce for, what, 35 years now?
Correct.
Anybody ever call you and say, I want to set up an appointment to come in and talk about a dissolution?
No.
Never. They call you and they say, what? I want to come in and talk about a divorce. We don't use the word custody in Illinois anymore. The idea was that if we don't say custody, people find it easier to deal with things. It's not a war, you don't have to win, you can't lose. Anybody ever talk to you about it? I want to know about an allocation of parenting time and responsibilities?
No.
Absolutely not.
Nope.
20 years from now, you think it'll change? Probably not. So sometimes we give things new names because we think it'll make things better. Sometimes we come up with different ideas because we think it'll make things better. While it has zero to do with the income shares, as you know, the Circuit Court and the Divorce Division just realigned itself, right?
Yeah.
How many times have it realigned itself since we've been practicing?
Yeah.
3 or 4?
3 or 4 times.
Change anything?
Yeah, and let me refresh the viewing audience out there. In January of 2017, January 1st, all the laws basically in domestic relations, family law have changed. We do not anymore refer, as counsel here has indicated, to the word custody. But he's right. I have people in my office, I tell them it's parenting time now, and that's what we're going to talk about in this discussion about your divorce. And guess what? After I talk to them about that for a half hour, they want to know who gets custody because they don't understand it, and it's very difficult to explain. So we're going to add all this new income sharing onto what we already have going on this year, and it's going to be a real catastrophe in my personal opinion. I know you disagree. Now, under the old law, if each party was earning $100,000 a year and dad had 6 nights or he had 14 nights of parenting time, it'd be difficult to obtain a settlement. One side wanted guidelines and the other wanted a deviation under the guidelines. Well, the deviation wouldn't work under Section 505 of the Domestic Relations Act because you have to show financial resources and the needs of the child, the needs of the custodial parent, standard of living, and physical, mental, or emotional needs of the child. Well, that just didn't fly. The new statute determines the gross amount of each parent. It determines the tax effect, and it uses a calculator or software program, just as you indicated, one being family law software, and I'm sure the FIN plan will be adjusted for that. And you use a published chart. That's what I showed the audience here, that you could cross-reference the total child support, the number of children, the total amount allocated for each parent to contribute. Sounds very simple, sounds very easy. I just suspect it's not going to be that easy. Now, if a parent has a child 146 nights a year or can employ a shared care child support obligation, then it determines the percentage of time that the non-primary has with the child and makes a further adjustment downward in the child support obligation. So these are all considerations. But what I'm feeling is going to happen here, you're going to have a parent who's not getting their, let's say, proposed parenting time, and they're going to come back into court after the new income sharing statute is instigated back in July going forward of 2017. And they're going to say, I'm not getting parenting time and I also want my child support adjusted. And there's going to be screaming by the opposing parent. Well, which law is going to apply?
Well, actually, there's a simple answer to part of that question.
Please.
The simple answer is that written into the income share statute is a provision that said, well, let me back this up. If you want a modification of support, the legal standard was you had to show a substantial change in circumstances.
Correct.
Usually means one party's earning a lot more than they did before, or earning a lot less. Under the income shares, the statute says that the mere fact that this statute is effective July 1st is not a substantial change. So you still have to come in, if you want a modification, and show a substantial change other than just the statute itself. So you can show, I earn a lot more, he earns a lot more, I earn less, he earns less, expenses for the kids have increased substantially. You've got to show those things. If you can get over that hurdle, then they'll apply the new guidelines.
I
The
tend to
income
disagree
shares.
with you on
Okay.
that. I think that once a new statute is in effect, that's going to be used as an excuse for people to come back into court. Notwithstanding the fact that you said that you got to show a substantial change in circumstances. I think the judge may take the attitude, yes, we have a new law out there, so let's apply the new law. Now, I may be wrong, but we're all going to see that and see what happens. I think it's going to be very costly, I really do, to all the litigants, this new statute. As far as just as this new Parenting Time Act that went into effect this last January of 2017, it's become costly. I could see in preparing a settlement agreement, you first have to have a parenting agreement filed within 90 days, and you have to have then a settlement agreement and everything else, and it all comes down to a lot more hours of work that the lawyer's going to be putting in.
Well, when you talk about the allocation of parenting time and responsibilities, it's an enormous amount of time.
Yeah.
I mean, it's just a total change from what we used to do. And I've seen some parenting agreements that look like telephone books from small towns.
Exactly. That's exactly what I see.
Some, you know, it's like, Johnny's going to have milk. Well, what brand of milk? You know, I mean, people sometimes go way beyond what's meant by these things.
Oh, absolutely.
But-
and you can't really cover every specific little aspect because you know it's like the Magna Carta. If you're
You know.
a parent and you take the child to the dentist every day before the divorce or before the separation, you take him to his doctor.
You know,
now
I
all of a
tell
sudden you can't do it
I
anymore.
tell clients all the time, I don't play the what if game because there's never an end to what if.
Well, that's
Just keeps going.
That's a true statement. Sometimes they don't like to hear that.
No,
though.
they never like to hear it.
There's a lot of things they don't like to hear. That word custody, they want it back, in my opinion. Now, because they keep talking about it. Well,
But I
didn't
think something we haven't touched on yet, which maybe deserves a minute or two. Well, actually, you touched on it when you talked about the camera. The income shares, you know, there are certain things that happen. They happened before. They're not changing because of income shares, but the statute is changing. And the one that was significant in my mind, only because I had somebody in the other day where this was a tremendous issue, depreciation on real estate.
How's that changed?
Well, how it changed is how it's applied.
It's applied.
You always are going to have on income producing property depreciation. Should depreciation be added back to show what the real income is for that property? I mean, no one takes depreciation out of their pocket and sends it someplace. It's a paper entry, that's all it is.
Correct.
Under the new act, income shares, there is no depreciation. You don't factor it in. Under the old act, some judges did, some judges didn't. I think for the most part it had to do with good lawyering.
Mm-hmm.
Good lawyers could make a better argument that their client was entitled to it, or make the contrary, that the other side wasn't entitled to it. Now, you're not entitled to it. Under the new act, business expenses that really aren't business expenses, and again, you know, my example is, you look at 3 years worth of returns from this business that's operated, let's say, by the husband. All of a sudden his income went from $100,000 to $65,000. Why did his income go down in the third year, which is the year they're getting divorced now? And now you look at the income of the business. The income of the business remained the same, expenses went up. Why did the expenses go up? Now you find out he hired his girlfriend. He's paying his girlfriend $35,000 a year. Diverts the income from him. It's not subject to support or maintenance. And when they go on vacation, the girlfriend pays, and she's paying a lower tax rate on the money to begin with. So they make out all the way around. The new act basically says if it's not a legitimate business expense, you add it back in. Under the old act, it didn't say it, but if you were a good lawyer, you argued it and you got it back in. So it's a nice change.
I agree, and I think that, as well as now they're not going to give you a lot of deductions for items that you write off in your business.
That you use personally.
That you use
Yeah.
personally, and we all know that that occurs.
Absolutely.
And it occurs quite frequently and to a big, big expense. And that's going to be kind of stopped as best as they can. but there's going to be more time put in. There's going to be more hiring of experts. There's going to be more of everything, and everything leads, in my opinion, to a big expense for the litigants. And also it's going to be a tougher job for the judges. And I can see now that the judges are going to be to wit's end as to which law to apply, which they've always had that problem when it came to a new statute. And they're also going to be to wit's end as to what is the right thing to do as opposed to what the statute says.
Correct.
And they're going to have that little discretion to be able to do the right thing, hopefully. But you know, it's been a great program that we had here today. I think that this is not a refresher course, but this is an opening of the eyes for the people out there, whether you're a layperson, whether you're an attorney, as to what's coming in July of 2017. Add that to what came in January of 2017, and we got a real hodgepodge of a lot of new stuff out there. And so get that computer literacy going, and get yourself as counsel here says, get yourself a software, whether it be FinPlan or whether it be the other software, family law software. Both of them will certainly provide you with the information that you're going to need. I want to thank all of you for watching this program on YouTube or TV, wherever you see it. I'm Barry L. Gordon, a member of the Chicago Bar. This is Burton Gross, and Mr. Gross is a, quote, super lawyer, and we think that we probably gave you a good bird's eye view as to what is going on. Thank you for watching a Chicago Bar Association presentation.
Thank you.